Good evening. Yesterday I had prepared, with the help of one of my associates, an opening in Russian. But I did such a poor job that I won't repeat the exercise, so I say it in English. Good evening. I am very pleased and very impressed to see so many people who have come at the initiative of Vadim. Thank you for that, and it's a privilege and a great pleasure to have this opportunity of speaking to you. It's also, when you get my age, you have a feeling of passing on the many years of experience. So it gives me great pleasure to have the opportunity of speaking to you. Vadim told me that you have already a solid basis, and he warned me not to go too much into basics. I will go into some basics, but perhaps with a different perspective. The perspective of the practice. That's why I suggested we call this practical experience, and some issues as we go along. I'll try to flag some issues. Feel free to interrupt at any time, either if there's a point you want to have further clarified or something you didn't understand, where I wasn't clear enough. Feel free, and perhaps at some occasions, at some spots, we make some interruptions if there are questions. When I sit as arbitrator, I am now known to be very impatient and interrupting counsel, so I have my prayer beads to control my urge of interrupting. Here I'm sitting in the chair and have the microphone, so I can speak as I in a privileged position. I suggest to go at some of basic points. What is arbitration? Not from the legal point, as perhaps you see it, but look at it more from a practical point, the practical obstacles, how the theory appears in practice, who are the players, and then some issues which perhaps hopefully throw some different light on these basic points. There are some aspects, especially with respect to the players, which I addressed yesterday. I understand one or two of you have been at the conference yesterday by the Russian Arbitration Association and the Swiss Rules and the Swiss Arbitration Association, so I apologize for the repetition, but I thought it would be useful to share this with you too. So to start with, I suggest to have a look at the players, the arbitrators, the parties and their counsel, and the institutions, and then look against practice today in arbitration. Why arbitrate? Does arbitration deliver the expectations and the promises that perhaps you are told, or the older people said arbitration does? And have a look against the theory, how does arbitration deliver in practice? And then a word on regulatory framework. I have, if there is still time, a few notes on investment arbitration. We can see if you have still absorptive capacity or debating spirit to go on with the subject. Now, with the players, as I said, the arbitrators, the parties and their counsel, and the institutions. So I suggest to start in looking at the players, and in particular with respect to the arbitrator, and the divides or differences I've seen in practice. Of course, arbitration, one of the great virtues is the diversity and the flexibility. So almost every arbitrator has a different approach, and it's of great importance that one knows the background and the methodology of arbitrators before you go into a procedure. But there are some basic lines. Now, You all have heard me, and there's much discussion about the civil law and the common law approach. But this distinction is to some extent misleading, because even within the common law and within the civil law, there are big differences. Procedure in America and in England, in many respects, is very different. The same procedure between Germany and France, or Spain and Switzerland, are very different. So when people speak about civil law and common law, beware. This is just a surface. Behind this surface, there are other differences. And there is also in arbitration the comparison between adversarial and inquisitorial, which I think also is often described as a basic difference in arbitration. And again, this is to some extent misleading. There is a very interesting article of one of our great arbitration specialists, Claude Raymond, who had an exchange with an English QC in one of the publications, where he's writing the civil law or common law, which one is more adversarial. And he came to the conclusion that there are inquisitorial elements in the common law approach and adversarial elements, and he said the civil law approach is just as, if not more, adversarial as the English approach. So again, don't stick to these categories, look behind the words and see the actual point. So now the first important point, which I find really as an important basis for distinction, is the role model of the arbitrator. What does he or she, the arbitrator, believe, how he sees his functions? And there, the two basic approaches, they have their reflection also in the civil procedure, is on the one hand the impartial referee, the person who watches the game being played between the two parties and sees to it that it's played fairly. And his role there is to see that each party has its opportunity of presenting its case, and there are no cheating, and there is a fair way of presenting the case. That's the one approach you find mainly in the common law, especially in the English tradition. The other is what one can call the dispute solver. That is the arbitrator who not simply watches a game and says this one is right and that one is right, but says we want to solve the dispute. You have that very much in the Swiss, German and Austrian tradition, where in the law it says the judge shall always see to reconcile the parties. Something that is anathema to an English arbitrator or English judge. That is not his function. So the arbitrator or the judge engages in working with the parties to find a solution. If no solution can be found, he must decide. But basically, the idea is to bring an end, the solution to the dispute. And this is why in this tradition, the role of the arbitrator intervening and getting into mediation is something perfectly acceptable. Whereas in common law practice, this is, you can't do this. In fact, when we were working on the notes on organizing arbitration proceedings, the Unzertrall document, I'll come to this, but I point out already that now it's a very useful document because it shows we were insisting on not providing best practices, but showing the diversity of different processes. And when we were discussing this, there was quite some resistance in the group of putting this even in the notes, and in fact the delegate or the observer from the American Arbitration Association, he objected that it should be, even the discussion should be recorded. So we said, well, the Chinese then have a similar approach to the German approach, and I had a friend who was sitting in Chinese, after German arbitration specialist was sitting in Chinese arbitration, and he said he felt more at ease with his Chinese colleagues than with the English colleagues, because there is this common approach of trying to settle, finding a settlement. So this is a basic difference. I've written a bit about this in an article which I prepared for the Russian Arbitration Day. I got some copies. I'm afraid there are so many of you who came, there may not be enough, or there perhaps is gone already. So if you're interested in that, I'm developing this with the background. There is a similar divide, which I also mentioned, that is between the way how the evidence is gathered. The approach in the common law is that you get all the evidence on the table. That's particularly pronounced in American civil procedure, where you have vast discovery. You have the witnesses being questioned before they even appear before the tribunal, collectively or jointly by the two counsel. The process is started with a very general description of the case. Then all the evidence is put on the table. I mean, it's a nightmare for us in Europe. The discovery, and especially now with e-discovery, that's even more problematic. Anyway, all is on the table, and then they start thinking, what can you do with this evidence, and how you can construct your case. Whereas on the continent, and especially in the Germanic tradition, there is what we call the Relevanzmethode, the method of establishing, you present your case, and then what is necessary for presenting as evidence for that case. But you don't produce the evidence, the other side then looks, examines the statement of facts, where they don't object, this is then agreed, and only where there is an objection, there is a need for bringing evidence. In the article I've quoted an English professor who says this is a horrible approach. How can you start looking at the law if you don't have all the facts on the table? Now, in arbitration, that there is a mixture of the two. There is a large extent of document production, but there's also a need for understanding the general context and not only have the evidence for the particular allegation or contested facts. Now, back to the arbitrator as a player in the game. What are the qualifications for an arbitrator? And I presume many of you one day think they would want to become arbitrator, and that's the question I get often: how do you become an arbitrator? It's a long way and a lot of luck. Moreover, there are training opportunities. I don't think any university that doesn't offer a course, an LLM in arbitration. So there are great hopes that are developed, and I think reality will be able to provide opportunities for becoming an arbitrator only in very small and very limited opportunities. Even the big law firms often they do litigation and arbitration at the same time, which creates problems in the way of dealing with the arbitration. So I'll go through it, and then you'll see what you find comfortable with. The first and very important message I'd like to say is that arbitrators are not judges. It's often you get the comparison that arbitrators are private judges or simply have the same role as judges, and I think it's important that you understand they're not judges, and of course there are similarities. Both must decide a dispute, but there are quite important differences, and it's important to bear this difference in mind. The first one is arbitrators and judges have a different source of their power. Judges are appointed by the state. They fulfill a function of the community, and they have a responsibility to the community, whereas they represent the judicial power of the state. Whereas the arbitrator is there because the parties have chosen her or him. So that's a very important difference, and normally I don't like to appoint judges as arbitrators. I mean, there are judges who have had enough experience, because an arbitrator, as counsel, I expect that he or she are responsive to what the parties expect, and are mindful of their role of a service provider, specifically to the party. Now, this makes a important aspect also with respect to the procedure. The judge has the state procedure, the law of civil procedure or court regulations, and they are prescribed by the state, whereas the arbitrator follows the procedure which the parties have agreed. There are in the law some fundamental principles, but basically it's the parties to agree, and if you have an arbitration, let's say in Moscow, you can apply the UNCITRAL rules, you can apply ICC rules, or you've learned all these different rules you can apply. I understand there are some restrictions in Russia about the institutions that need to be accredited, but basically there is the choice of the rules, or there are top rules. So originally, before you had all these rules, it was simply parties agreeing on a procedure. So that is another important distinction, where the parties agree. Of course, the arbitrator then, if the parties don't agree, must decide on the rules, and sometimes also the parties may agree on aspects of the procedure which are not very practical. So the arbitrator can also have an advisory role in saying, don't you want to consider this or that aspect, and often arbitrators do that from the beginning. But that is a basic difference in the rules that are applied. Now, the arbitrator also, both arbitrator and judges must decide, but the decision of the judge and the arbitrator have another important difference. The decision of the judge is solving the particular case in front of him or her, but also is developing the law. So judges are quoted, or the decision of judges, and the higher in the rank you are, the more important these decisions are for the development of the law. And that is part of their function. Arbitrators, first of all, their decision, especially in commercial arbitration, their decisions are in most cases not known. You have decisions of commercial arbitrators being published, but there is a very interesting article of Francis Mann, a very outspoken English, German lawyer, immigrated to England, and he says, what is this unknown arbitrators whom the state hasn't chosen? How should that be a basis for developing the law? And to a large extent, he's right. There are certain circumstances in which arbitral decisions have an importance beyond the individual case. That is especially the case in investment arbitration, where there is a very similar framework in the treaty-based arbitration, where there are a large number of treaties with many provisions which are very similar. these treaties, in many respects, they have slight differences, but are similar. So arbitrators deciding a certain case will look at what other arbitrators have decided. But this is not really a precedent in the sense of court precedents. It is a particularity of investment arbitration. There are other systems which are relatively closed, where the decisions have a sort of presidential value. For instance, in sports arbitration, the arbitrators are also a function of the system itself. The FIFA has certain rules, and the arbitrators function within the system of the FIFA, and therefore play a role in the development of the system. But basically, there is normally arbitrators don't have the role of developing the law. Another difference, and you see there are many differences between arbitrators and judges. Another one is the way how they are selected. The judges are appointed by the state or certain mechanisms. You've seen recently a very, well, call it dramatic way how the Americans appoint their Supreme Court judges. It's perhaps not an example for the rest of the world, but it shows that that is a political process, and because the courts have a public function. Whereas arbitrators are appointed for a particular dispute. The judges have to respond to a great variety of cases, depending on the judicial system. One day they may have to decide a divorce, and the next day the sale of land. Of course, in some cases, in some countries, you have specialized courts, but basically the judge can't choose the case that he or she have to decide, and the parties can't choose which judge should decide. Whereas arbitrators are appointed for their particular case, which requires that the parties can expect and often look at case-specific qualifications. That, I think, is an important part. I'll come back to this, but that is something to be borne in mind. The arbitrator cannot and should not react like a judge and simply limit himself to the legal issues. The arbitrator is expected or is appointed for a particular dispute, and therefore should have some competence and some understanding. And that is really one of the particularly important aspects, and I find this as one of the problematic aspects, that arbitrators are often not enough responsive to the non-legal issues. First of all, the legal issues. I recently had a debate in Egypt with the arbitrators there, who said arbitrators have a foreign law. I say no. A judge has a foreign law. The Russian judge is appointed by the Russian state, applying the Russian private international law rules, and that's his law. The arbitrator appointed in Russia, in Egypt, or in Switzerland may be appointed in a dispute applying Finnish law, or applying Egyptian law, or Swiss law. And that, even if he's trained in a Russian university or an English university, that is not the foreign law. The law of substantive law, the law which the arbitrator applies is the law for which he has been appointed. Now, it often happens that arbitrators are appointed for disputes to which a case of the law is applicable, which is not the law in which they have been trained. I once had a case where the ICC appointed me as the chairman of a tribunal that had to apply Finnish law. So I told the ICC, thank you very much, very honorable appointment, but I don't speak Finnish and I don't speak Swedish, so I can't even read the law, and I have no training in Finnish law, so I will rely on what the parties explain to me about Finnish law. So the council and the ICC said, don't write this, we can't, we can't, if you say this, we can't appoint you, but there is a Finnish party, and according to our rules, we can't appoint an arbitrator of the same nationality as chairman, same nationality as one of the parties. And there is nobody, or practically nobody in the world, no arbitrator in the world who understands Finnish and who's not a Finn. So I understand now, I learned that yesterday, there are in the Ural in Russia certain people in a republic that speak a language which is very similar to Finnish and which they understand each other. So I discovered new things, but anyway, they were not on the list, on the short list for arbitrators. So it means, as arbitrator, you have to deal with other legal systems, and it is particularly problematic if you have on the tribunal one specialist or one arbitrator who knows that law and the two others don't. For instance, we have in Switzerland a lot of cases with Turkey, because Turkish law is very similar, but very few people in Switzerland speak Turkish. So if you have a tribunal with a Swiss, a German and a Turk, the Turkish member has a larger part. So the lesson from this is a essential part, and that is one of the big lessons I learned from Professor Pierre Lalive, one of our founders. The lesson is an important qualification in the legal field for arbitrators is comparative law. You have to understand enough of common law principles or generally comparative law. I had another Finnish case where it was not chairman but co-arbitrator, also with Finnish law, and we had a Supreme Court judge from Finland and a professor from Finland, and we were discussing from my comparative law aspect, I could situate certain issues, even if they look different. And if you look in comparative law, I had as a student, I was editing the German edition of the review of the International Commission of Jurists, and had to look at English or French decisions. And sometimes I looked at it, it's strange what is the reasoning of the judge, but in the end, despite different principle, the results are similar, because judges, one of their objectives is that their judgment makes sense. So even if there are different ways of getting to the same system, we had a very interesting comparative law issue. It was a long-term gas delivery contract. I'm sure you Gazprom was not involved. It was between two other countries, and our client said the supplier is unreliable. So in winter, when they needed the gas, the supplier used the gas for himself or for its own organization, so less came, and they said that is a quality of the gas which should lead to a price reduction. The contract provided not for national law but for general principles, and we argued price reduction for deficient quality is a deficiency and allows price reduction. Now we had there four legal specialists arguing. The other side, price reduction is not an international, a general principle of law, because in English law you don't have a remedy for deficient supplies as price reduction. So, and they said in the Vienna Sales Convention this is introduced, but against the will of the English, and they finally accepted it. And in England, the Sales Convention, Vienna Sales Law is not very popular. So then we sat with these experts, and then I asked, I was counsel and was asked the English specialist, you're saying you don't have price reduction as a remedy for deficient products. But the reduced value of the good, which, because it is deficient, gives you a claim for damages. He said, yes. So I said to the tribunal, you see, the two systems have different labels, but the effect is the same. A deficient good, I think in Russian law, you have price reduction as a remedy. Yeah. So in Russian law, in a sales law, a deficiency in the good, you either get damages or you get price reduction because it's it's a lower value. In English law, they don't call it price reduction, they call it damages. So if you just stick to the label, you have a problem. But if you look behind what the effect, you see the difference. This is why comparative law is such an important factor in international arbitration. The other aspect is the knowledge in Finnish law, or Turkish law, or Russian law, is already for a German lawyer, or a Swiss lawyer, or a Spanish lawyer, already specialized knowledge. But there are many other areas of specialized knowledge in an arbitration. Maybe civil engineering, maybe metallurgy, maybe accounting. And one of the problems is, how do you deal with specialized knowledge in which you're not trained? And one of the most interesting things in arbitration is you learn all these different things. One of my first cases was a road contract where I became a specialist in asphalt mixing. You think it's easy to just put tar and pebbles together, but it's very complicated. Anyway, I won't go over to asphalt mixing now, but I became a specialist in asphalt mixing, and you could see how the mix deforms depending on the pressure of the road and the density. So you learn. And then I had recently a case of a submarine cable from India to Europe, where there were problems. The cables lose the signal after something gets weaker and weaker. You have to strengthen it, like compressor in a pipeline. So these stations that re-strengthen the signal, they have certain mechanisms. So very few people understand these mechanisms, but in the arbitration where you have to understand it, so I have become a specialist in repeaters in submarine cables. There are many other areas. They don't have much of a daily practical use, but they make life interesting. So there are two different ways in dealing with with specialized knowledge. One is, I'll give you an example, you earn a lot of money in the lottery and then you want to invest it in the bank. So we'll go to your banker and tell him, I have this money, I want to invest it. So the banker gives you all kinds of explanation about the stock exchange, and they have these fantastic, they foresee the future, but the future doesn't follow what they have foreseen, and all kinds of methodologies. So you can either say, he is a bright man, he knows his business, I do what he tells me, I buy Google shares or Siemens shares, as he or obligations of the American state are. Anyway, what he said. Or you say, I want to make my own decision. I won't be a specialist banker, but I want to understand enough that for my personal decision I understand enough. And that is, I think, most, if not all, decision makers are confronted with. It goes for politicians. They have to make a decision about the health system of the country. They are not specialists, they are not doctors, they get experts. And there are in different countries guidance how scientific experts have to behave towards the politicians, the advice they give, so that you distinguish that from lobbying. You have in other areas, managers of a company, they need to know many different factors so that they can make the right investment decisions. So what the decision maker needs to have is not the specialized knowledge, but I saw that sometimes ago, and I was very happy with the expression, Zugangswissen. The knowledge that gives you access to other specialized knowledge. You don't need to be a civil engineer, but you need to understand enough of civil engineering that when you hear the two experts, you can make head or tail and say and understand what they're telling you. And I think this is one of the most important and one of the least understood elements in arbitration, that arbitrators should not act as judges who have to rely on the training and the reputation of experts, because they say, I believe this one or that one. Or for instance, you have it in American trials, jury trials, where you have to qualify as an expert before you can speak to the jury, because the jury, you can't expect that they have this capacity. But arbitrators are appointed for a construction dispute, so they should have enough Zugangswissen, knowledge to understand what the civil engineers are telling them. Same thing with quantification. Sometimes when you are in arbitration and people start talking numbers, you see the jalousie closing of the arbitrator. There is the Latin saying, "Judex non calculat." The judge doesn't calculate, but an arbitrator should be able to calculate. Of course, he's not there to make the calculation, but understand what is wrong with one calculation and the other. So that is a very important element for arbitrators in general, and in international arbitration, there is another very important aspect. That's what I call cultural sensitivity. People express themselves differently. They have, let's say, we had a case between a Japanese and a Swedish company. One of the problems was that there was a licensing contract, and the Japanese licensor had deals with other Japanese companies, and they were paying licensing fee to him, and then the Swedish company had a right over these licensing fees. And this was, the dispute then was supplied to a construction site for certain piling works. And in Japan, the company, the contractor, picked up the phone, talked to the piling supplier. We need next week 20 piling for this site in Indonesia, and that was it. When it came to the arbitration, the other side said, "Where's the evidence?" The Japanese system functions if a Japanese businessman says to another Japanese businessman, "I want this, you don't need a contract, you simply need that." That is their common basis. If he doesn't deliver, he's socially lost. Similar, you have similar things like in commodity, or a very interesting, the diamond trade, which is in the hand of very small group of people, no paper. They're in Antwerp and Tel Aviv, and things just go. You have to understand that people function differently. Also, there are cultural differences, what you say and what you don't, how you argue. Some people are more outspoken, and the additional point is language. Arbitration, or in the world, there are more non-native speaking English speakers than the few Americans and the few Brits. I mean, I myself am, we call that offshore English, and the Brits and the Americans tell us how we should speak English, but all of us, I don't know, there's no English mother tongue member here in the room, and we all speak English. But the possibilities of misunderstanding are great. There's a very interesting book I recommend to read it for Tibor Varadi, Language and Translation in Arbitration. Varadi is his name, V-A-R-E-A-R-A-D-I, Tibor. And he, of course, is already interesting. He's a Hungarian, grew up in Slovenia, and was teaching till recently. I think they had problems with this university in Hungary. Was teaching in Hungary. Exactly. So you have cultural sensitivity. But it's a very interesting book, and how he says sometimes you can understand the English, the meaning of in English what the party meant if you understand the mother tongue of the people who wrote it. He gives an example of a word that has a double meaning in Hungarian and very different meaning. And if you look at the English word, if they pick the wrong word from the dictionary, if you don't know there's another meaning in Hungarian for that word, you don't understand. So these are things of importance for the arbitrator. That is this cultural sensitivity is something that's also very interesting to see how different people react according to their background. And then probably the most important thing is what you call in English judgment. It's not what the court delivers as judgment. It's the common sense. The common sense that what the arbitrator decides makes sense. And I've seen awards with many pages, with many footnotes and intelligent quotations, but the result didn't make sense. It doesn't fit in the business environment. And parties, especially in commercial arbitration, go to arbitration because they want to have somebody who understands the business and makes the right business decision that they can say they can live with. So that is something really important. And in the discussion about who wrote the award, and I will not discuss now the case where the secretary writing the award played a role, but I know arbitrators who have a professional team of associates with whom they work and who do a lot, and I still have confidence in arbitrators like this because I know they have judgment. They just get it right. Of course, there's an advantage in writing the award yourself because when you look at the paper and when you write, you think. But basically this element of judgment is of critical importance. Final point is the arbitrator must decide. So there are different characters. Some arbitrators have difficulty in deciding. They send it back to the parties, try to agree, or take a long time for deciding. That is something very important. That you have to listen to the parties, but then you have to make a decision. There is a difficulty because sometimes getting it right needs some distance. I sometimes feel at the end of the hearing the tribunal should be able to right away make a decision, and sometimes that could be possible. But basically, you need to have a step back, and you could call this decanting in wine. If it has to settle so that it gets all the full flavor and all the elements. So there has to be some balance between really getting the full aspect and the same time. Sometimes when you have to decide about the post-hearing submissions, there are lawyers, and especially English Queen's Counsel, who are very eloquent speakers, and you tell them something and they get up and make a beautiful speech. Who can, at the end of the hearing, make a beautiful speech? I can't. I've tried it once or twice, and we thought at the end of the hearing, now is everything clear. We can have the next morning, we can have a final closing argument, and it was bad. We were working the night through, and it turned out to be more complicated. And I hadn't slept very much. I wasn't very good at speaking. And then 2 days later, I realized all the good things I could have said, but it was over. So sometimes we had for closing argument the weekend, so that over the weekend we could sit and think through what we've heard and what was done to make a hearing. But basically, I think I need time, and many other people need time, precisely for this decanting, and the arbitrator also needs time. So that is my view on all the qualifications of the arbitrators as a difference from judges, but in general what one expects or should expect from arbitrators. A last point on arbitrators, the party-appointed arbitrator. There is a big debate about the bias of party-appointed arbitrators. There are people who say when the arbitrator is appointed, he or she should forget who appointed them, should be neutral, and only think of making the right decision. I think that's the wrong attitude. If you see how the importance the parties take in choosing their arbitrator, the time that is spent in choosing the arbitrator and the expectations party have, and the importance it has for parties to have their arbitrator on the tribunal, replacing this by the institution appointing all three arbitrators, I think simply, I mean you can do this, but it simply doesn't meet arbitration. And especially in international arbitration, where you have different approaches, different views, but even in domestic arbitration, in a construction case, the perspective of the contractor to the project and the perspective of the owner are very different. And to have somebody in the tribunal to have these concerns, and to have somebody in the tribunal, if I appoint somebody as my arbitrator, I want to assure that this person makes sure that my arguments are understood. They may be wrong, and I don't expect of him to say they're right, but I expect of him that he sees to that they're properly considered. And sometimes when I sit as party-appointed arbitrator, and the party that appointed me loses on a point, I myself write it, so as to make clear to the party that appointed why they lost. Because sometimes you simply, that's the worst thing, to lose and don't understand why you lost. What the tribunal didn't consider your arguments, that's really frustrating. You lose, I mean that's part of life. And even if you think it's wrong that you lost, but if you see the tribunal made an effort to understand what you have to say, and I think the party-appointed arbitrator has this responsibility. But that is only one side. That's only one side of the party-appointed arbitrator. At the same time, he or she are a member of a tribunal of three, and they owe loyalty to their colleagues. So they have to jointly make an effort of finding a solution. So there is a conflict in the party-appointed arbitrator, and we have to be aware of this conflict. There's no good of avoiding conflicts. I mean, I once saw the difference between Europeans and Americans is that we are more trained in ambiguity. The Americans, everything must be black and white, right or wrong. We grow up more with the ambiguous history we're having. And in fact, it may go back to Greek tragedy, where conflicting situations, like take the famous play of Sophocles, Antigone, the principle of raison d'état of Creon, the king of Sparta, and of Antigone, the owner, what she owes to her brother, that her brother is being buried, and you have this conflict of two valuable principles that are irreconcilable. And we learn, or should learn, to live with these contradictions. And there we have a typical contradiction, and it is wrong to eliminate one or the other, to solve it, but simply to find a solution to this. And if you're, I think your first appointments are likely to be party-appointed arbitrator, bear in mind that you owe loyalty to your colleagues on the tribunal, that you make a joint decision, and at the same time you have a responsibility to the party that appointed you. That is perhaps not quite as orthodox. There's a lot of talk about arbitrators should forget who appointed them, but I think this is important. Now, I've talked a lot about arbitrators. I have as a next player the parties. Of course, that's what it is about. The parties to an arbitration, and they're there. The whole arbitration takes place because they're disagreeing. And I think what's something to bear in mind is that in arbitration, in most cases, it starts with a contract. So the parties had enough commonality that they could agree on something. And then something went wrong. It could be the circumstances changed, the party that has to pay the money doesn't have the money anymore, or the market changed, or they have different orientations, or simply misunderstanding. And often communications play a big role. Trust disappears, and once in a relationship trust disappears, everything one party does is seen as wrong. Now, what is important from the perspective of the arbitrator is that they start the case with the assumption that both parties have a good reason why they're in the arbitration. So for counsel to say the other is a liar or a crook doesn't go well with the tribunal, because they start, or especially the chairman, doesn't think of, perhaps in the end they understand one is a crook, or perhaps they're both crooks, but to start with, as an arbitrator, you think, I want to understand why they're here, and why should they fight with each other, why should they pay a lot of money for this arbitration, why don't, there must be something, and to understand this difference, I have an image which I often tell to our younger associates. You all know the Matterhorn, this famous mountain in Switzerland, you know, the peak you have it on the chocolate, and it has a very clear shape. That's the shape when you look at it from the Swiss side. When you look at it from the Italian side, it looks different. And that's with reality. One party looks at it from the Italian side, the other from the Swiss side. And the part of it is, for you as counsel, to communicate how your party, to the tribunal, how your party sees the Matterhorn. Of course, there is also a construction of reality. There's a big debate now about the reliability of witnesses, how reality is a construct. And the bias of the observer and the way how your question also influence your picture, your image of reality. All of this plays a role. My first big client in the law firm was a German industrialist retired in Geneva. And I was a young lawyer just coming out of a traineeship, and we were working together, and he had a way of seeing things. I gave him then, if we had a problem, I gave him a legal analysis, all like we had it learned in law school. And he said, Schneider, can't you see it here? And there was a small part of the sentence which had a different meaning. And he said, can't you see it? You with your university education. And then I understood how much it makes, how much difference it makes, how different people look at the same matter. So that is very important for your role as counsel, to see, to understand. The counterpart to this is that you have to have the courage to tell your client you're wrong, or tell your client you have to understand the other side sees it differently. And I have a client in a big company, and they're the responsible person, but we had once a meeting with our expert. He told the expert, I don't want you to tell me what I want to hear. I want to tell you what's wrong in my position. Because you are here now, you can tell me, and I can adjust my case. If I hear this in the arbitration, at the hearing it's too late. I can't do anything about it. So you as counsel, you have the responsibility to tell your client where there are things wrong with this case. Sometimes, depending on clients, that they don't want to hear this. Or sometimes they don't tell you the right story. I had a case where, my first case was an Asian client who was well introduced, and he told me a full story. And I had just come out of traineeship. I was at the federal parliament, so I wrote the German organization. explaining this case. So when we then had a meeting at this organization, I realized it was all wrong. So they put the papers, so yeah. That taught me a lesson. But there are people who are embarrassed to tell you their mistakes. And that's also a cultural difference. I think the Americans are more relaxed of saying, well, that's a mistake. Especially I think for Asians is very difficult to admit that there was something wrong. And I had once a case where for over an hour I told there was something that was not clear, told my client or the managing director of the company, questioning him. And I was embarrassed of questioning him so much. I said, it's not that I don't believe you, but you will be questioned like this in cross-examination. I said, no, this is like this. So then finally, okay, I accepted it and he argued the case on that basis. Shortly afterwards, the other side produced a document that showed he was wrong, he was lying to me. So that was very embarrassing, and the really bad thing was, had he told me the truth, we could have changed the case, produced it from a different angle, and it wouldn't have been so bad. But since we were lying, it was very bad. And the top of it was the other side's lawyer, who was a friend, thought I was lying, and he was very upset. And fortunately, there was a junior who reconciled us again, but he thought Schneider did a terrible thing. So that's a very important thing for you as counsel, to work with your client on the right story. And sometimes the truth is not as bad as your client thinks. They're on a certain track, but if you look at it from a different angle, you may not get the same thing, but something similar, which then, sorry, I'm telling stories now, but I think I said I'm talking about practice. So, I had a case between two companies in a joint venture building a factory, a processing plant for a certain mineral. And my client's organization had taken a certain approach. And it was Swiss law applicable, and they asked the Swiss lawyer, he's told them what they wanted to hear, but they had an inkling that wasn't really right. So they asked me, and I said, yes, what he told you isn't really, it doesn't work. But if you look at it from a different angle, you don't get the same thing, but something that comes close to what you want. But the relationship between the two parties had been so blocked, so we said we'll have to introduce now an arbitration. And we did a very long request for arbitration, over 100 pages, precisely to introduce this different approach. Now in this industry, well, there are some industries which are very combative. The construction companies, they're very combative. In this industry, they meet once a year for having a nice meeting together, the few companies, and it's really very consultative. So before we filed the request, the CEO of the company called me in his office and said, Mr. Schneider, can we really do this? Make a request for arbitration against our friends on the other side? I said, I'm afraid here you have to do it. So, and in order to keep speaking or open the door again, we said we don't appoint our arbitrator. We suggest in the request for arbitration that the parties jointly appoint all three arbitrators. And we suggest that we meet to discuss the appointment of the arbitrators. That gave us the possibility of not saying we want to negotiate, but gave us together to get together. So we traveled to the seat of the other side, and it was very friendly, like these companies work together. We had a preliminary speech, and then everybody went to lunch together. And the legal counsel of the other side said, Mr. Schneider, of course we are in opposite camps, but I have to tell you what you wrote was a good submission. And it shows you that just for him to say it, it shows you how different companies in an arbitration can be. We then agreed, we set up the tribunal, we agreed that there should be a mediation, and the party settled once they had understood the different ways of looking at it and could reconcile it. So this is the important part. The message I was making here was to be able to tell your own client where you see the mistakes. The other point is to get to the evidence. And there, it depends, we were discussing that with the General Counsel. It depends there on the position of the General Counsel, who normally is in charge of the arbitration. But there are different people in the company dealing with different aspects and with different audience. There's the project manager and there's the assistant project manager and another person in the organization. They may have different views. So it's very important that, and the General Counsel often only has second or third hand information, so that you get to the real source of information. And I'm normally not very fond of witness statements, but that is a great advantage of witness statements, that you get to the person in charge of, the knowledgeable of what went on, and you discuss with him. And then you get new insights of the case and get the relevant evidence. Often I do a lot of construction work, and then the project manager on a project, the case is a project in Saudi Arabia, but by the time it's in the arbitration, the project manager is already in Thailand. And he has other problems. He doesn't have time for this old dispute that's over. So you have to mobilize them. And I had one client who, whenever there was a case, he appointed a person in his organization whose only task was to get us the information we wanted and to get us to the people we wanted. So this communication between you as the lawyer and the organization is a very important point. So these are the points which I wanted to make about parties. I come to some other aspects later. There's a last point is the construction of the case. You will hear different voices when you prepare the case, but the real art is to bring this together into one message. And the simpler the message, the better. And it must be in a sense that the arbitrators think, yes, your party was wronged, and the wrong has to be put right. And to have a short, clear story. And it's often difficult. Sometimes it's not possible, but this focusing on a clear story. In a construction case, the contractor is either somebody who made a low bid, lower than his costs, and he hopes to catch up afterwards with the variation. So he makes all kinds of claims. If the tribunal sees your client like that, you have a difficult case. If the tribunal sees your case as a contractor who has in front of him an owner who is stingy, who wants to squeeze every penny out of the poor contractor, you have a better case. So it's, that's a simple example, but you have to think how all the elements lead into a clear story. That, I think, is one of the arts of good counsel, to bring the complicated case into a clear story. But you have to understand that you've spent a lot of time in understanding your client's case, and the other side is trying to complicate the case or destroy your case. So the tribunal gets lots of different information, and your role as counsel is to help the tribunal find its way through this message. So the construction of the case, and that means not only the law and the facts, but also all these technical issues. That's why the understanding of technical issues is so important. Now, last player are the institutions. I'll be short, I'll have some other comments later, but the main thing is that the institutions have become more and more important for organizing as a basis for the procedure, finding the mechanisms, and in particular appointing arbitrators where the parties don't agree and decide on the challenges. And this function of appointing arbitrators or selecting arbitrators is the key function, because the good arbitration depends on the good arbitrator. So when you're looking at choosing an institution, the costs of this institution, and I'll come to that in a moment, are insignificant compared to the importance of their capacity of finding the right arbitrator. We made in the Swiss Arbitration Association some years ago a comparison competition between our institutions, and one of the questions are, who are in your institutions the persons who make the choice, and what is their qualification? How I as a party can trust that the institution can find the right arbitrator, because it's already difficult for the parties. The parties know already about the dispute, but the institution have an idea about arbitrators, and their experienced institutions are better because they have a better overview. But that, I think, is the key function of institutions. You have institutions who are now they're competing, and they're making rules and all kinds of conferences, and there's a lot of going on in the competition of institutions, but they are trying to play a more important role. One of the big issues, they are working on the timeliness of awards. So these are important. They have more and more put into the forefront, but the main thing is the appointment of arbitrators. Now, my next subject is why arbitrate? What does arbitration today deliver? What the parties expect? The traditional answer is faster, cheaper, flexible, finality, enforceability, and to have a look how in practice this works. Now, I'm speaking for 70 minutes. Do you want a break, or do you have questions now before we continue, or how do we do it? I love speaking, so I can continue, but I mean, the problem, I find it terribly difficult. There's one guy who's speaking all the time, and I have to sit there and concentrate on what he's saying, especially if he's speaking fast. So if you want a break or have questions.
Can I have
yes.
one question? We were speaking about appointing authorities, and what do you think about situation when appointing authority appoint himself as an arbitrator? I knew some few cases, but nowadays it is not very important, or so there is no rules on this.
I think good practice is that they don't. The appointing authority, we had a case with the PCA. I think that's
Ukraine and Russia.
Yes, no, it had nothing to do with the Russian. It was a different case. But the point there was the contract wasn't clear. The arbitration clause designated the PCA, but in a way that it wasn't quite clear whether they had chosen it as the appointing authority. So the PCA in that situation said, normally in the Unsittard rules we are designating authority, not the appointing authority, but they designated themselves. Otherwise it would have been very difficult to handle. But basically, I think you're right. We had the problem in Egypt where the director of an arbitration center appointed himself as arbitrator. That was not very much appreciated by the parties. That has been changed. So I think the standard rule now is that an appointing authority shouldn't appoint. And in fact, there are many organizations that have a practice of even removing, for instance, in the ICC court, if a member of the court is in one way or another involved, or a member of his or her law firm is involved, they are removed from the decision making.
But nowadays we can't challenge arbitrator on this basis.
I beg your pardon?
So on the basis they are appointing authority appointed himself, we cannot challenge this arbitrator.
That depends on the applicable law. There is normally, there was an interesting case where an arbitrator was challenged before the ICC. The challenge was dismissed, and then the challenging party went to the courts of England, and the courts in England said, yes, we can. We have our own criteria and our own jurisdiction of challenging the arbitrator, but they did dismiss it also. So depending on the applicable law, you have recourse at the place of arbitration under the Lex Arbitrii. We had a big debate in the UNCITRAL rules. You know, the UNCITRAL rules provide, you have to specify the appointing authority. If you haven't done so, the PCA, the Permanent Court of Arbitration in The Hague, is the designating authority. That is to say, they, under the UNCITRAL rules, do not appoint, but designate a person or an institution to make the appointment. When we were revising the rules, there were people who were saying this is too complicated. Have the PCA as the automatic fallback position. We had a big debate, and there was a whole group that said this is the simpler way, and then especially the Asian delegates, they said we don't want to have the Secretary General who was very adamant about this, said we don't want to offend the PCA, but the PCA for us is a European institution, and we don't want them as the fallback position. So it turned out that the cases in which the PCA has to appoint or designate an appointing authority are very small. So we said we stayed with the rule. So the PCA is only designating authority. But they can also, before it wasn't even clear that if they are designated as appointing authority, you can write into the contract appointing authority at the PCA. That wasn't clear whether they even could do that. Now, in their own rules, they can do this. But the rule still is now, if you don't write anything, the PCA, and no rules, PCA can also only designate the appointing authority and not designate itself. Mm-hmm. Yes?
I've got a question about, you've spoken of a situation when you presented the parties as a counsel, and you understood clearly that the party lied to you during the preparation of the case. And what's the strategy when you clearly understand that your client is lying? Would it be right to just reject the further communication, or what's the decision in this situation? What's the solution?
When you're counsel in the arbitration, you have your own reputation, and an important part of that is credibility. If I say something as counsel to the tribunal, I believe in it. I wouldn't say something which I know is wrong. The English barristers have a very interesting formula. When they don't believe what they're saying, they say, I am instructed to tell you. The client may not understand, but the tribunal or the court will understand that the barrister tells you something which he doesn't believe. There is a very interesting difference in the ethical rules of the bar. In the English and American practice, you are responsible for your client. And that comes out in particular in document production. You have to see that all documents, no matter how damaging they are produced. And if your client is lying, you have to tell the tribunal, my client is lying. In my book, I don't do this. I don't lie myself, and I don't use the elements that I don't believe in as evidence, but I have no duty to tell the tribunal my client is lying. I had a horrible experience. That was a case where I came in after 2 rounds of pleadings. The counsel who had argued the case on my client's side was intelligent but totally confused. And it was difficult to understand what he had, and I read the transcript at the hearing. I knew the president of the tribunal, and I knew him. He was very rather sharp, and I thought how patient he was with his counsel. And then the client realized there was something that wasn't right. So they wanted the legal opinion from me, and then as we advanced, said, okay, can you take the defense? And I looked at the case. I wanted to reconstruct it because it didn't look right the way I was presented. I was given another opportunity to make a third written submission because I wanted to understand what the case was about, but I couldn't change too much. The basis for the case as it had been put were timesheets. It was the erection contract for a power station in the Middle East. And the supplier was a German company that delivered all the equipment to the site, and then it had to be erected. They were late and were under pressure. So the local company, they would put a lot of energy, they bought big cranes and then erected this power station, and that's quite complicated. But of course, erection is not something in a sequence like building a house where you start at the foundations. You have different ways, and they claimed for all the disruption. And they demonstrated the disruption by these timesheets. So I was trying to understand these timesheets by different different team managers, and every time I got a different explanation. And I didn't feel well with it, because I really didn't understand. So I said, okay, let's try to put them aside and build the case on other evidence we had. And but I couldn't withdraw them. So at one of the hearings, the project manager was questioned, and it turned out he had fabricated all of them. He changed the names in it. And that was on a Friday evening. That was the worst weekend I had. Especially since I knew the arbitrators and I felt very embarrassed towards the arbitrators. That's also an interesting cultural element. This company, they had made a major effort in getting this project completed in time. They bought new cranes, hired people, and really made a big effort. The responsible person in the German company said, don't make change applications, etc. Concentrate on doing the work, we find a fair solution afterwards. When the project was over, this German manager was removed, and the new people said, you want to claim, where's your evidence? So they didn't have the evidence, and the guy said it's unfair, so he made the evidence himself. It's one way of doing your justice, but this type of situation can arrive. But had I known that these I felt uneasy enough that I didn't rely on it. I didn't tell the tribunal, look at this evidence, that's the evidence I put forward. But they were on the file. I couldn't say, well, I didn't see that I had the duty to say I doubt whether my client is telling the truth. And that is one of the problems with the rules on, or the guidelines for party representation. There, the IDA made, among the many rules they made a set of guidelines for party representation. And one of it says you have to insist with your party that they produce all the evidence. I don't think that I can explain it. I can tell the party you have to produce this, these are the rules, but if they don't do it, that's theirs. So I think, I don't know how it's in Russia, the bar rules, you are expected to tell the truth, but what your client does, you're not responsible.
Well, we generally are expected to tell the truth.
Of course, yeah.
Yeah.
And it's also a question of your own credibility. I rely on, when I say something to the tribunal, that goes also with cases or things, that the tribunal has confidence in what I'm saying. But I wouldn't say, if I know something is wrong, or if I had known they were fake, I wouldn't say this is evidence. But that you are, that you have to resign, in that case, in that case I was close to resigning. But then there was a change in the organization, and we managed, and it didn't turn out too bad. But basically, it's there's a difference in the bar rules in this respect. Sorry, I forgot your question.
You answered it.
I answered it? Okay, thank you. Yeah. But you've heard already some of it yesterday.
Well, I want to escalate the theme of lying from the clients. I have some questions.
Yeah, okay.
If I'm understanding it right, your relationships with your client are based on contract, yeah? Are there any statements that shows the responsibility of your client for telling lies to you? So if we consider reputation as one of the main assets for a lawyer, if you're telling lies and your client is guilty in it because he told you lies and you didn't need it, it's not good information. Yeah. How can you restore this reputation in law society, if we can talk about it, and gather money from your client, for example, or are there any other commons to solve this conflict?
Now, place yourself in the situation of counsel. I am your client, and you tell me, Mr. Schneider, you are liable not to tell lies to me, and if you tell lies, you pay damages. Would you tell that to your client?
Well, I guess so.
You would, yeah. Well, I wouldn't do so. I would say, of course, you have to tell the truth, but to tell the client, I conceive the possibility that you're telling lies to me. I think that's difficult for managing a relationship like that. I told you this other example where I was sitting with the client where I thought it's not right what he's telling me. But I didn't tell him, are you telling lies? I told him, you will be exposed to cross-examination. So all these questions I put to you, it's not because I don't believe you, but because you have to answer these questions. There may be a cultural difference, but there's a politeness between you and your client, and you have to find a way. And if you think there's a problem, you have to way of telling it. But I wouldn't write into the contract, you pay damages if you lie to me. Would you do this?
Well, no. But how will you restore your reputation after telling lies in school?
I told you I had it in two cases. I think I managed to restore. In that case, simply by continuing to be honest. And the tribunal understands. In that case, the tribunal understood that it was not my fault. But it's a risk. But the main thing is be careful. Other questions? Is there? No. Can I go on, or are you exhausted?
Is the audience exhausted? Do you want the break?
Yeah.
Well, yeah, so we can have the 5 minutes break, I guess. And how much time are you going to speak up to the break
I can speak as long as you want. No, I have lots of things. As you can see, I love the subject, and perhaps I go through and we pick up some points. I skim through the rest. What's your feeling? No, but when did you say? Oh, it's already 8. Oh,
Yeah, so, well, probably if you have like half an hour to,
okay.
That will be fine. So after the break, we'll have, okay. So, break 5 minutes.
What I had prepared was to look at arbitration practice and see whether arbitration is really faster, cheaper than other procedures, of course, compared to alternative procedures like mediation or other new forms. I think you've heard of them, dispute boards and procedures of this nature. The advantage, of course, is that these other procedures can be faster, cheaper, but of course you don't have an enforceable document unless the parties agree, but you may not reach agreement. We had there a very interesting case that was on one side a Japanese company, on the other side the Swedish, was similar to the other case I mentioned before. And you know, the Japanese are very reluctant to go into dispute and into confrontational procedures. So, but they realized they wouldn't make any progress. So they said, okay, let's have a mediation. So we had we agreed on the mediation, and then before they went into the mediation, they asked me, how does this go? I said, I can tell you how it starts, but I can't tell you how it continues. And you shouldn't want to know how it continues, because you should keep an open mind. And the Japanese are very organized. And they discuss in the group from the top to the bottom, everybody, and then decide on a strategy in advance, and it's all organized. So to tell the Japanese you don't know what's happening and what's going to happen, and you should know what's going to happen, that's difficult to accept. But they discussed it, then they accepted it, and they were fully in it. And in fact, they were better at it than the Swedes on the other side, because it's also important that you speak to the other side, not like in an arbitration, to the tribunal. You have to convince the other side. So there is a special technique for counsel, for mediation. I don't know how common that is in Russia. It's becoming in commercial disputes more and more frequent. Is that a frequent procedure, mediation? No?
Well, I've never heard that was frequent. Maybe some other.
Anyway, it's
correct me. As far as I know, Russians prefer to litigate heavily.
to have a clarity of the decision. Okay.
No, one of the reasons is yes.
Anyway, there's now the Singapore Convention of the enforcement of mediated settlements. The speed of arbitration, there are a few exceptions where arbitration is fast. That's commodity arbitration, which often is what they call look and sniff arbitration. There is a cargo of wheat that is rotten, so you go to the look and sniff where the cargo is rotten. But in fact, traditionally, they even exclude the lawyers. It's just the merchants. And that's an old way of arbitrating among stock members of the stock exchange. There are different stock exchanges in Liverpool for cotton, London for grain, shipping, and these forms. Normal arbitrations last 1, 2, 3 years, or sometimes even more. What is interesting, if you, I was going to look at the different stages where you can accelerate. There is a big movement now to accelerate in the proceeding, in the preliminary procedure, the expedited arbitration, and especially the emergency arbitrator. We just started a case, and in 15 days you have to have a decision. So that's a big trend now. The difficulty is, first of all, in this preliminary phase to decide on arbitrators, 1 or 3. There the rules have different approaches. The ICC has a fallback position as 1 arbitrator. The non-cital, we agreed on 3. So to decide on the numbers, but then finding the chairman. No, I shouldn't say chairman, because that is politically no longer correct. There is now, you've heard that, where a lot of people agree that they put more women into arbitration. I can't be objective because our law firm has a woman as a managing partner. We have quite a number of, even on the partner level, women. So I can say I don't think this is a good idea because the criterion should be qualification. There is a big problem which we are trying to address also in the firm, that women want to get children, and that is they have their private life too. And if you have let's say a case where you're expecting 2-3 years, and one of your associates or one of the partners will then step out for 4, 5, 6 months, or you have maternity leave, it's difficult to plan. So we're trying to handle this by assigning the case properly that it can be handled. But this is a point in some institutions go very far. I hear that from the ICC Court of Arbitration now says they have half of them are women. So they're saying that's a big achievement, but some of the women have very little experience. So you have to find a balance between and it's also a question of choice of women. Where do you want to have your career? In many firms do not organize the work in a way that a woman who has both career and family aspirations can progress properly. Do you accept in Russia the man's children leave, or rather maternity leave, paternity leave?
In most of the cases, it is maternal leave.
No.
So
You can't say the wife goes back to work and the husband takes care of the children in the firm.
no.
That's not accepted. In Scandinavia, that's accepted. We're just, we had a partner meeting yesterday and doing that in the firm to allow paternity leave.
Well, as far as I know, formally it's not like prohibited, but in practice,
you know,
men rarely go and take care of children, so mainly women do this.
So that's still a macho society? Okay. Anyway, it's something to be thought about. Interesting question I wanted to touch on is how do you get information about arbitrators? That has become a big issue. If I have to choose an arbitrator, I know quite a number of them, but it is one thing to have seen the person speak at a conference, and another thing to see him operate as an arbitrator, and that can be a disappointment. So generally within the firm we say, we have this case, whom would you think an arbitrator who speaks Russian, knows something about construction and is a fair arbitrator? So go around, or we say, what do you think of Mr. So-and-so who is proposed? So that's within the knowledgeable group, and they're now trying to open this up by the GAR has the arbitrator, what's it called, arbitrator research tool, where you get information about preferences, qualifications. You have websites, but still it's one of the most difficult things in advancing in an arbitration to get the information you want about arbitrators. Now, another point in this aspect is the interviews. Parties sometimes want to interview the arbitrator before appointing him. You find this is admissible? If I want to appoint you as arbitrator, my client says, I want to speak to her first and see whether I can trust her, or you think that's admissible?
Yes, why not? That's reasonable.
And of course we had a discussion and said, of course, there's such a responsibility. And of course we, in the business, we know the person, but the party doesn't. And they want to get a feeling. Of course, there are limits of the questions you can ask. And there's even a protocol of the Chartered Institute about what you can ask. But I think that's something that's not infrequent. Now, you can't change much in accelerating this part. One of the big problems that is coming now is conflict of interest. The situations which are taken as conflicting getting broader and broader. I've had in our people say we're in the same club, or we went to the theater together, or things like this. And the other point is that with the big law firms, there are so many possible situations which have to be disclosed or nominated. We had one case with two large international companies, and it was so difficult to find the chair, the president. It took a whole year until we found, or the parties found, somebody who was acceptable to both sides and who was not conflicted. And then we had a protocol of what activities were conflicting and what the other members in the firm could take in terms of cases. So that is one of the big problems nowadays. Now there is one thing I wanted to discuss, that which is also much discussed. That's the so-called double hatting that you have especially in commercial arbitration, people who sit both as counsel and as arbitrators. And there is a big debate that this shouldn't be done. The case that created most of the objection was a case where a famous lawyer, who is the head of the arbitration department of a big law firm, a professor, and also sat as arbitrator in a case where a legal issue appeared which was also relevant in a case in which he appeared as counsel. That's described as issue conflict. Now, in investment arbitration, that can happen because the number of issues are relatively limited. In commercial arbitration, this is very rare because most of the issues are factual, technical, and I have a more skeptical view about the rejection of double hat, because I think it has great advantages. First of all, to have an arbitrator who sat as counsel and knows what it means to be counsel, the time pressure, the problems with the client, all the organizational matters makes a big difference. To have a professor who's never done this, he has more difficulties understanding these problems. And the other way around, for a young lawyer to have sat as arbitrator, you learn so much about what passes, what is acceptable to arbitrators and what not. Well, I said in the beginning how aggressive you are, how much it is important that your argument as counsel responds to what the arbitrator's thinking rather than attacking the other side. So that's a good, very good school for young lawyers to be good lawyers if they have the experience as arbitrator. And there's one thing which I understood when I was an executive committee of an arbitration center. We had a number of small cases, and for that we wanted also to appoint young arbitrators. But if the young arbitrator has just come out of school and has or is in academia, where not in a law firm, this is difficult. You don't know, he or she would not have any surrounding to assist them, especially sole arbitrator is a very difficult task. So one thing we thought was preferable to have young arbitrators who are associates in a big law firm with an arbitration department. So they have experience as counsel, but they will not be allowed to have so many cases, and they are expected. We allow our associates to sit as arbitrator, but not too often. So the experience is one of the ways how young lawyers get into the roles of arbitrator, that they are in the law firm, and the law firm allows them to sit on a small case and then takes them back as associates. So this is why I think the double hat debate is not is a problematic issue and should not be overly pushed. In investment arbitration, it's a bit different. Now, I've spoken about the emergency arbitrator, the different procedures, the tribunals or the possibilities. I leave aside the different questions of the procedure where there are possibilities in shortening, where one of the big issues is availability. The question is also how you organize it. The standard now is procedural order number 1. The chairman, or the president, chairwoman, Gabrielle Kaufmann-Kohler, she was once said, chair, she said, I'm not a chair. So the word now is president. So the president, before even discussing, pulls out of the drawer or the computer procedural order number 1, where everything is regulated in detail. Some of it is useful, but it's anticipating things that may or may not come. The problem is that availability, if you want to have a week, or in the English style, 3-4 weeks of hearing, you need to get the 3 arbitrators and all the counsel and the experts and the parties together. You need a very long term in advance, so you lose flexibility in this. But all of this is in procedural order number 1 and become very much standardized. So the problem I see with this, and also with regulations, all the guidelines, I have a whole chapter here on guidelines, which get more and more, and everybody, person or group, thinks they have to contribute to justice in the world by making their guidelines on all kinds of things. And the IBA is a great chartered institute. They all make guidelines. So I sat down and wrote the guidelines for the production of guidelines. And I'm a bit skeptical about this, and I think that one of the big problems is that it gets more and more regulated, and we lose the flexibility, and that's why at Unzitral we're putting out these notes, and I recommend looking at these notes for preserving the variety and the flexibility in the adjustment. Now, costs. There is a big discussion about costs, but you have to look at the cost factors. The arbitrators and the institution, there is the statistics from the ICC, in the order of 20%. All the other costs are the parties. And more costs now for experts. I had a case where the experts were more expensive than counsel. and you get millions of dollars in fees for counsel and experts, and to deal with this, it doesn't help much to cut the fees of the arbitrators because it makes a relatively small percentage. The real thing is to organize the procedure that the fees are lower. There are discussions to say in the beginning of the arbitration how much should be the fees. You can't prescribe to a party how much they spend on their lawyers, but the discussion is that you say what is the amount of fees that can be reimbursed in the cost decision. That is an approach, but you don't know in advance, and it's also in the relationship to your client. Often clients more and more either want to put a cap or want a fixed amount for your fees, and that is a very difficult thing to deal with because you don't know how the arbitration is going to evolve. So what we do, we make a procedure, saying these are the steps in the procedure which we expect, and we quantify these steps, and on that basis we make a budget. But we say this budget is variable. If there are different steps in the procedure, then there are changes, and we have to adjust the fee. But that, to put it in an arbitration procedure, that is very difficult. I skipped all the different approaches to the organizing the procedure. It's quite interesting to see. You have a standard now, a double exchange of written submissions in document production, which I think is far too frequent now. I've had a case where I was co-arbitrator, and both parties were Egyptian lawyers and from the Middle East. The chairman pulled out his standard document production, procedure order number 1, and after the first round of pleadings, there were 2 months for document production. I said, do you know that the parties want document production? He said, no. He said, no, Egypt said, no. Okay, he said, let's ask them. So he asked them, will the lawyers renounce document production? I said, how can a lawyer, if he's asked, do you renounce document production? He can't say yes. He wants to protect his field, but there are these standards now. There is, I think you have heard of it, the Prague Rules, a new initiative that is trying to shorten this. The process is still in development. They are modifying. There's a printed version, but it is still under review. And I think in December they are hoping to adopt the rules. So it would be good if you have a look at it to see about the procedure. The role of expert. That's something I find very important. As I said, the arbitrators should have the capacity or the knowledge to access specialized knowledge, which means, first of all, and you as lawyers also should have that, it means that your case is constructed together between the factual, the legal, and the technical elements. There is the saying that the experts are hired guns that are supposed to defend a case. But if the expert tells you something that doesn't fit your case, you shouldn't change the expert. You should change your case and adjust it. That the whole is a whole. There you have, of course, the traditional, different traditions, the party-appointed experts, the tribunal-appointed experts. Predominantly is now party-appointed experts in Russian courts. How do you get expertise? The court appoint experts?
Well, usually the parties suggest the experts, but the court may appoint it themselves.
And the court defines the questions.
It depends.
Yeah, that's a good lawyer's answer. It depends.
There are several possibilities. If the parties want, they can chip their own experts and then they can do their own expertise. So afterwards, the court is just to decide whether it's possible to accept the results of such expertise or not, or there is another possibility. The court can just define itself the experts.
And they're court accredited experts. Experts accredited to the court.
Yes.
In arbitration, it's mainly party-appointed experts. The civil law tradition of having court-appointed is less. I'm using sometimes experts of the tribunal, not for a third opinion, but assisting the tribunal in understanding the expert evidence. We had a case, there was an offshore installation where we had 3 naval architects advising the tribunal, or in delay analysis in construction cases, or quantity surveyors for quantification. So there are moves now. I wrote a piece on removing the experts from the adversarial procedure to treat them as objective truth and treat them different from the lawyers, which is more and more the case. But I think the experts in nuclear physics have just as diverging views as we lawyers, and so that should be recognized. I see. That's he's a very good chairman. Now, the practical reasons why, despite all these difficulties going to arbitration, is often there is no choice because of language, practical reasons between a Chinese and an Argentinian company. Neither party wants to go there, neither China nor to Argentina. So arbitration is the solution. And the big thing is enforceability, which is much better, much easier with arbitral awards than with court judgments. Finality is something that is a great advantage, but it also has its difficulties. If you get the wrong award, you're not happy that it's final. So to talk about finality, you have to see where you are, but basically that's a great advantage, and it's not sure that if you have an appeal, that the appeal court gets it better. There is, if you're interested in English law, there is a very interesting, very funny book by A.P.H. Herman, Uncommon Law, 99 misleading cases. And one of the cases, it's an old book connecting different mock court reports, and one is Why the House of Lords, and the note discusses the appeal and is saying the Court of Appeal is deciding whether they should allow access to the appeal to the House of Lords, the old version. And they're saying it's like you go to a surgeon and he says you have to take out your appendix, takes out your appendix, and then you go to another 3 surgeons and they say it's all wrong, you have to put the appendix back in. So the question is, what's up to 3 arbitrate or an appeal arbitrator, do they know better than the first one? So the whole idea of having appeal proceedings is not a very good idea. I had the saying of Professor Hirsch, one of our great arbitrators, who was very inquisitive in discussing the case with the parties. And he said, you know, we have to excuse us that we are so inquisitive, but we don't have the benefit of the Court of Appeal behind us. So we have to get it first, right the first time. So he's saying the choice, and that also should have the impact on how the case is conducted. I think I'll leave the other notes for your questions or for my next visit. I enjoyed that very much, and I noticed how attentive you were, and that's a great compliment to see. I haven't seen anybody go to sleep, so I'm grateful to you for your attention and proud of myself that I kept your attention. So now time for more questions. You're exhausted.
Well, I actually have a question. So let's say we have communications between a party appointed arbitrator and a party to a dispute. So in which circumstances this may lead to annulment or an award in the future, especially if we're talking about investor-state arbitration, because I think in commercial arbitration the answer would be it depends on the applicable law, right? But in investor-state arbitration, there's like one applicable law, which is the IT, which usually does not govern the procedural issues, and the previous practice case law. So what happens in investor-state arbitration in this case?
Well, the first thing is to detect the communications. I mean, I've seen or heard about cases where in the deliberations an issue came up, and then shortly afterwards the party made a new submission dealing with this point. I think the best thing there is that the issues, the concerns that tribunal has, are put on the table, rather than saying that letting it leak. I think there are leakages that you can't do much about. What the real problem is, if the party appointed arbitrator leaks the information about the outcome to one party, and then they get into settlement negotiations, and they reach a settlement where one party knows what the award will be and not the other. I don't know whether that. If you reach a settlement with a different information, you don't get an award, so we can't annul the award. But otherwise, why would it lead to an annulment? Well, because the unfairness. No, what's wrong in the award?
Well, the wrong thing is that the principle of secrecy of deliberations is undermined. That might be a formalistic argument, but this is one of the cornerstones of arbitration.
Is it?
Well, I think so, yeah.
But you know that in Switzerland, the Supreme Court traditionally deliberates publicly. Each judge has his opinion. It's become less.
That's the Supreme Court, not arbitration, not the panel.
No, I'm saying that means the secret of deliberations is not so sacrosanct. You can have, in fact, it's an old tradition in Switzerland. In the interest of transparency, they, because the judges are politically appointed by the parliament. But the public in the 19th century, that's when this started, said we want to see how our courts function. I'm mentioning this, that the secret of deliberations is something. It depends on the tradition. Some you don't even have. Well, if you have dissenting opinions, you also have a breach, or at least in some respects, a breach. So I'm not so sure that this is an absolute principle. And I think what you have to look is how is one or the other party affected. Does it create unfairness? I gave the example of negotiations. There is clearly an unfairness that one party knows and the other doesn't. But otherwise, I'm not sure. I can't give you a definite answer on that. I would say, as our colleague there said, it depends. I don't know, and I don't. I think there was in Sweden a case that was annulled on that basis, but I'm not sure.
Thank you.
I have a question.
Yes?
arbiters would declare themselves incompetent due to unenforceability of their award.
Ah, that's your question. Vadim just asked me the same question, so that seems to be a major problem here. Why would they? Because you don't know where the award is enforceable. And the fact, when I told Vadim, I just had a case, the Kyrgyz case I mentioned, many years ago, between Kyrgyz government and a Turkish contractor. I've read a few weeks ago that they are trying to enforce the award in Canada. Nobody would have thought that this arbitration where we sat in Bishkek would be enforced in Canada. So the enforceability is something that you as arbitrator should bear in mind, but the enforceability is not a final ground. In fact, there are cases where a party wants to have an award, is entitled to award, even if it's known in advance and it's not enforceable or will not be enforced. That's especially in insurance cases. Or in international case, you have often cases which are where the exporter has an insurance for sovereign risk or for non-performance. And I don't know, is there a Russian export risk insurance or export guarantee? Like in England, it's the export ECGD, the Exim Bank in America, COFAS in France, all these different organizations that fund and insure exporting companies against these risks. And if the risk occurs, the company gets reimbursed, mainly not fully, but 80% or 90%, and has to conduct the proceedings. Even if they know, we had a case with Libya, even if they know Gaddafi wouldn't pay. So I think the enforceability is not a necessary element for jurisdiction. Sorry, you're arguing this in
No, I was interested if the parties are from one state and they decide to define another place of arbitration, like the parties both are Russian, but they decide that the place of arbitration will be Sweden, and the arbitrators know for sure that their award will not be enforceable in Russia.
But then it may be enforceable somewhere else.
So it's not a crucial point for arbitration.
I don't think so. I told Vadim, he put the same question. From what the argument as I have it now, I would say I would decline this objection against jurisdiction.
Can I ask?
Yes?
What are the reasons for double heading? Is it just lack of specialists in some sphere, for example, investment arbitration?
When we appoint arbitrators that are also lawyers, it's often because of their qualification, their experience in arbitration or in the subject matter, that we know that they are familiar with a certain industry, and also that they have sat as arbitrator before. In investment arbitration, there are quite a number of arbitrators who only sit as arbitrator. Many of the famous ones are, in fact, they may have been before in law firms, but then they set up their own chambers or their own firm, also for reasons of conflicts. But it's mainly because experience, and you want to have somebody who knows the business.
Mm-hmm.
Yes?
Thank you very much for the lecture. I would like to ask a question about...
Can you take the microphone a bit closer, please?
Sorry. You've mentioned that arbitrators can have different legal backgrounds, and as we know, for example, some legal concepts are treated as a procedural law in some jurisdiction, and another are treated as a matter of substance of the case. For example, limitation periods, how they differ in common law and civil law jurisdiction. How arbitrators basically deal with this complexity and different concepts?
That's one of the issues, most difficult ones. It's a question of characterization and what rules of conflicts of laws do arbitrators apply. There are different approaches. Either you say the arbitrators have to choose conflict rules, and these conflict rules then will tell them which substantive rules are applicable, and then there is often the argument that it should be the conflict rules at the place of arbitration. But these conflict rules are made for the courts, not for arbitration. I don't know an arbitration act that has conflict rules. Well, the Swiss Arbitration Act, Chapter 12 of the Private International Law Act, which is for international arbitration, says the arbitrators apply the law which is closest related to dispute. Article 187. That is a conflict rule, specific for arbitration, but most acts do not have that. And then rules. And the Unstall and the ICC rules is normally the direct application. The arbitrators don't choose first a set of conflict rules and through this the substantive rule. They directly apply the rules that they consider most closely related to the dispute. But then if there is a difference. I think the question of characterization was first dealt with by Havel. There was a case, a German-American case, precisely with, as you say, with periods of limitation. And in that case, there would have been no limitation because of the way it's different characterized in America and in Germany. Now, the characterization, the conclusion of Havel, who dealt with that, was you characterize legal form, that is to say, at the form the law at the form, that is to say, we had an interesting case with interest where there is a similar problem between English and some civil law countries. Interest for us is substantive. In England, it depends on what type of interest. If it's compensatory interest, it's part of damages, then it's substantive, but statutory interest is procedural. So in that case, it was arbitration in Switzerland, and there is no procedural, or the lex arbitrii was Swiss law, but Swiss law arbitration law has no rule on statutory interest, and the statutory interest in England would be procedural, but the tribunal accepted that it should be characterized according to lex fori, that is to say, Swiss. But these are very interesting. I mean, the private international law issues are very nice acrobatics.
Thank you very much.
No more?
Well, if there are no further questions, we would like to thank you for the lecture. It was very nice to hear from you. Thank you.
Thanks to all of you. It was a very nice experience. I will look back to it with great pleasure and good memories. Thank you.